In the spirit of reconciliation, Law Squared acknowledges the traditional custodians of country throughout Australia and their connections to land, sea and community. We pay our respect to their elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples today.
Well, welcome everyone. Thank you so much for being here. I am Squared Group's Chief People and Capability Officer, Cassandra Hatton. It's great to be with you again today for our latest webcast, New Working From Home Laws in September 2026, What Victoria Signals for the Future of Work in Australia. So when the right to work from home becomes law on the 1st of September 2026 in Victoria, it will no longer just be a perk, it will become a protected entitlement and a world-first reform. These new laws are the clearest sign that workplace flexibility is shifting from cultural expectation to legal infrastructure. While Victoria may be the first state to legislate, it likely won't be the last, signalling a shift for our national future of work. So today we'll focus on what the new entitlement covers, including where the exceptions sit, how to identify the roles and employment arrangements that are affected, the legitimate grounds to refuse a request, how disputes are best resolved, and what updates are needed in your contracts, policies, and position descriptions. We'll also go through what these changes may mean for the rest of Australia. So we're going to cover a lot of ground today. If you've joined a Law Squared webcast before, you will know the drill. You can ask any questions for our speakers in the chat, and our moderator, Alicia, will gather all of these up and will respond with some answers to the frequently asked questions over the next couple of days. So let's start by introducing our panel of experts. We've got a couple of amazing people here to take us through this content. Firstly, we have Katie McWar. Katie is the Human Resources Manager at Loon, where she leads the people and culture function for one of Australia's best known, and I'll add best loved, hospitality businesses, now at 9 locations across Australia. Katie brings an analytical, risk-aware approach to HR, interpreting legislation, working with data, and coaching managers through complex employee relations decisions. Having progressed from a pastry chef to senior HR leadership, she offers a grounded, practical perspective on how workplace change actually lands for employees and managers. So welcome, Katie. Great to have you with us.
Thanks, Cass.
Also, we have Andy Brooks, our Head of Employment and Workplace Relations at Law Squared. Andy will be well known to many viewers today, having worked extensively as an employment law advisor to many of Law Squared's clients across both the for-profit and not-for-profit sectors. He's also the driving force behind a library of free legal resources aimed at helping organisations comply with the employment legislation and emerging trends in the workplace. Those include respect at work and psychosocial hazards. And his team is very busy at the moment with numerous litigation and workplace investigations underway, with the recent very large uptick in claims across Australia. So welcome, Andy, once again.
Thank you, Cass. Happy to be here.
Amazing. So let's just start right at the beginning with what this new entitlement covers from a legal perspective. So Andy, does this actually create a protected right for everyone in Victoria to be able to work from home?
Oh, I feel like I'm going to be so boring, like every time I get on these webcasts. Similar to the right to disconnect, I would just preface it by saying it's not necessarily as groundbreaking as potentially it sounds. So maybe I'm happy to go through kind of what it is and then maybe more importantly what it isn't. So effectively what it is the ability for eligible employees, so not all employees, so casuals, unless irregular and systematic, they're carved out, probation period employees, they're carved out, apprentices, interns, they're carved out, can effectively put in a notice. So they call it a notice because it sounds a little bit more like a right, like an entitlement, but in effect it's just a request. So they have the ability from the 1st of September, if the bill goes through, as it currently is, for normal businesses, and 1 July later on for small businesses, to put in this notice to say, hey, I want to work up to 2 days a week from home if they're a full-time employee, or if they're part-time, kind of a pro rata. So they can put forward kind of this notice, hey, I'm full-time, I want to work 2 days from home. These are kind of the days I want to work from home. And then the business has 21 days to kind of consider the notice, but I consider it a request. And then it can go through kind of whether it's reasonable or not. So the business only has to kind of approve it within 21 days if it considers it reasonable. And it can be part of those discussions where it goes through in terms of kind of what days they would work from home, how it would work. And then it's on the employer to cover any reasonable costs in terms of them working from home. But it's limited at the moment under the bill to equipment and software required to like access your servers. So for a lot of people, this would simply be a laptop, and that would only be if they're not already provided with one. And then kind of like the software licenses that they can actually access the workplace things. So for a lot of white collar workers, it might just be Outlook that they can access from their laptop. So again, not very costly. It doesn't go into at the moment in the bill in terms of like big flashy workspaces, dual monitors, doesn't talk about coverage of internet or phone allowances. Because in reality, a lot of those things would already be in an employee's household. So it is really looking at that hardware kind of specs and then software. So that's, I guess, kind of the boring answer. What it's not, so not everyone can apply for it, as I've kind of said. It doesn't mean you get flashy workplaces, as I've said. And in my view, and maybe I'm being a bit killjoy on this, it doesn't necessarily have the impact that I think some people are flagging. Like if I was to put my pessimist kind of cynical viewpoint on, employees already have the ability after working somewhere for 12 months to put in what they call like a flexible work arrangement request, which allows people to say, hey, I want to work from home. The only limitation on that is it needs to be connected to like caring responsibilities or parenting or their age. So there's those limitations. And this, in effect, only kind of expands that. So it just means that someone may be out of probation after 6 months. They don't need to be connected to parenting or caring or their age. They can just put in this request. So in my head, it kind of just makes it easier for employees to work from home, and it makes it harder for employers to say no, but it doesn't make it impossible. So is this an inherent right to work from home for everyone? I think the kind of annoying, boring answer is no. If you're a business, that's good news because it means that you can kind of keep doing what you're doing. And if you're an employee, it's probably bad news in some ways in that it's not automatic, but at least you've got more of a pathway to go through. For employees, it also kind of gives them this kind of ability to dispute a decision. So similar at the moment to flexible work arrangement requests, where if you put, hey, I want to work from home because I've worked here 12 months and I have caring responsibilities, disputes can go through to the Fair Work Commission. Because it's Victoria-based for this piece of legislation, you have to go to the VEO-HRC, which is a bit of a mouthful, but it's like effectively our discrimination tribunal. But it's the same kind of process. You kind of say, hey, my employer's terrible. They said no to my request. And then it goes through that dispute process. So that at the moment, that's kind of how I'm thinking about it. It's just an expanded right for Victorian employees or people based physically in Victoria to say, hey, can I work from home? And it's a bit harder for employers to say no. But that's how I would kind of summarize it to begin with.
That's a very helpful summary. Thank you so much. So given that it's not as wide-reaching as some were reporting, who do you think will be most impacted by these changes? What types of industries and businesses would you say?
It's such a great question because it kind of depends on which side of the aisle you're on. If you're an employer business lobbyist at the moment, they're putting out these kind of 10-point plans for how basically all business in Victoria is going to dry up because of these changes. And they will point at it's so onerous and hard that businesses will leave. And if you're on the employer union side, you're effectively saying it's this great entitlement and right that people probably have the ability to do anyway, so it won't have any real impact. But really, when I think about it, this decision, because it only gives the ability to request up to 2 days, it really will only impact businesses that are a little bit more traditionalist, that don't necessarily have a work from home set up at the moment, but arguably could. So you're looking at those kind of firms or businesses that maybe are a little bit more old school, that make everyone work in the office 5 days a week. The businesses or organisations that have roles that just can't work from home, like your healthcare kind of organisations, like they won't be impacted by this largely because their employees just physically cannot work from home for a lot of their roles. So in terms of which industry or group, I'm really just looking at the groups that are very strong at the moment on 5 days in the office. They're probably the ones likely to get impacted the most. And your more flexible workplaces, they're probably not going to actually get the impact from this. So that's kind of how I think about it in terms of who's impacted.
Yeah, that makes sense. That makes sense. So there's a task here for organizations to identify what roles and employment arrangements are affected across all industries. So, Katie, there's obviously always the legal side, which is very important, but the practical can be even more important to getting these types of things right. So, for the listeners, firstly, perhaps you could run through a little bit about Loon, including how many stores you have, employees, locations, the head office split. And before we get into the nitty gritty of the law, simply how did it first land with you? How did the changes land with you when you heard about them? Was it scary, or did it just support the status quo that you already have in place?
Yeah, okay. Well, I guess Loon Croissantry forms part of a bigger group, the Loon Co. So, like you said before, we've just opened our ninth store in the Gold Coast. The remaining 8 stores are across Melbourne, Sydney, and Brisbane. We also have a lesser known little sibling business called Moon, which is our 10th store opening up in De Grave Street in Melbourne very shortly. So, across our workforce, we've got about 300, just under 300 employees, and our central head office is located in Melbourne. So, very much applicable in terms of the legislation change and our cohort that's actually eligible, but a huge chunk of our employees aren't. So, in terms of how I felt about it, probably a little indifferent, purely because we already have a hybrid policy in place and it's exact alignment to the legislation change anyway. But I did find it pretty interesting because I'd been looking through sort of other organisations and job ads and seeing whether people sort of just decided to, it's inevitable, it's coming, but it does seem like there's no real change in how people are requiring 5-day in office, on site. The traditional employers that Andrew was talking about, they really seem to be digging their heels in, I think, which I think is an interesting take when, it's probably just making it harder for themselves, but
Excellent. That makes a lot of sense. It's going to depend on, it's going to be different for every business, isn't it? And so I think for the listeners, they're going to be thinking about the changes and how they can effectively categorize people into different buckets. And so it sounds like for your business, you have people across multiple hospitality sites as well as head office. How are you thinking about drawing the line between roles that genuinely can't work remotely and those that can? And how do you manage the fairness conversation when some of the team qualify and others simply don't?
Yeah, I mean, we're lucky in the sense that a lot of it is actually very clear cut. So, I mean, I just can't, never say never, but I just can't fathom the argument with a pastry chef who suggests they can take the marble bench and planetary mixer home with them. Like you just couldn't do that. But I think one thing is that fairness doesn't necessarily equal the same thing, and they're just not comparable roles. So I would go as far as to say maybe it's not about fairness at all. And in this case, between a corporate head office and a production or service role in a venue, where it gets a little bit more nuanced, or where I think our challenge is going to be, is possibly those sort of senior management roles in still like within the operational teams. So there's argument that, well, they do a small amount of administration outside of being on the tools. So do they actually have the ability to do that at home? And would it be unreasonable for us to say no? And so I think it's probably just about being really clear in our reasoning about why yes or no. And if we can't really come up with a good enough reason ourselves, we probably just need to test our thinking again, because maybe it is just time to explore that.
Absolutely. Yeah, it is putting the pressure on organizations to be a bit more open-minded, isn't it? And I also think there's a distinction here between have to and then also the cultural bit is who are the types of people that we're attracting to our business? What kind of conversations are we having about why we want to be in the office, why we don't want to be in the office, especially at leadership level, how we're leading people, etc. But there are going to be some tricky conversations, I'm sure, across many businesses, including the conversation of refusal. And so, Andy, the changes do include an exhaustive list of reasons an employer can use to weigh up in deciding whether it's reasonable to refuse a request or not. And it's a closed list, so nothing outside it counts. So take us through that. What are the grounds that are included in that list?
Yeah, happy to. And there's kind of two main areas that I kind of see that they list out in terms of what a business can do to say no to something, because we can't just say we don't want to. Basically, we have to be able to point to something reasonable that we can list on the rejection notice. So first one is inherent requirements of the role. So again, as Katie kind of mentioned with pastry chefs, you kind of have to be there to be able to use the equipment. You kind of can't perform your role if you're at home with a laptop. So it would be easy for pastry chefs to be able to go through their PD and cross out all the different things that they can't do from home. So that's going to be a pretty easy one for the inherent requirements of the role. If your role is kind of customer facing or client facing, and it is a organization where clients and service recipients actually come through the door physically, it's really hard to be able to provide the same level of service if you kind of set up, even if you could set up a giant screen with, my face on it, greeting people coming in. It's just a very different experience for the people coming in. So, the obligation is to consider it. Could we still do that? But oftentimes, if you can't actually do the things on the PD, then that's a really easy way to kind of knock back a request. They still want you to be thinking about, say, could you do 1 day from home and 5 days in the office and still do the inherent requirements of the role? Or if we had technology and not my stupid big screen idea at the entry, but like other reasons or other things you could do, then that could work. So inherent requirements is always going to be your easiest one. And that falls through for other employment law things. Rejecting flexible work arrangement requests also falls through. So that's inherent requirements of the role. And then the next one's a little bit more subjective, which I think businesses are going to try to fall into when they can. It's this impact on the business. So they list out a whole bunch of different things that they say that you can think about that I'll kind of look awkwardly to my right on. So significantly impacting or reducing productivity or efficiency. So it's not just, hey, this makes you slightly more inefficient. They're wanting to be able to show it's significant as that impact, whether it adversely impacts someone's safety. So for example, like if you're an OH&S coordinator and you kind of need to be walking around seeing what people are doing, again, the technology solution of having a robot with a screen and pointing in different directions is probably not going to cut it. So that's a way you could kind of knock it back. Significantly harming supervision. So if, again, you're performing things at high risk that need supervision and there are no tech solutions to be able to do that reasonably, then that's an easy way to reject it. Impacting training or professional development is another one that they list, which I think a lot of businesses might be able to use for their more junior staff members. It obviously isn't a catch-all, like just because they're in their first year doesn't mean that you can reject or work from home, but it does kind of point to this idea that it can be inherent requirement of the role sometimes if you're a junior employee to be involved in decisions, to be in different meetings. If you're able to show that you can't actually get the training and development working from home, some people would fight you on that you can't, but there are definitely some roles in which that would be the case. And some other ones, significantly harming the ability to build relationships with clients or stakeholders. So again, that kind of walking off the street kind of piece, I think that would have an impact. Harming confidentiality or data protection. It's that's going to be a hard one to fall down on or fall on, because part of the kind of process is, can you put in place reasonable kind of processes or machines that they can take home to use? So it would only be if there's kind of, you're such a secure organization that you actually can't have remote work because the risks are too high from people working off the cloud or accessing it separately. There are a lot of NG kind of infrastructure businesses where decisions have to be kind of made in very close-knit rooms where they don't allow remote kind of access. So that's something else they might look at. And whether it would be impractical for work arrangements or for new hires. So again, just something we're kind of thinking about in terms of when the rejection might be. And it might just be that you reject it for a certain period of time and then invite them to come back to you when, say, they're not a new hire anymore, or to go through it like that. But those are kind of the main things. So I always think about, can they do everything in their JD, even with reasonable sports? And how significant is it going to impact the business? And I think there'll be a lot of companies to say it significantly will impact the business to have one admin person working 1 day a week from home. And I think that's when they're going to become unstuck, because I think it's going to be hard if it goes to the VEOHRC to be able to actually prove that. But yeah, those are the two areas we're kind of looking at. The inherent requirements of the role, and then impact on business, basically.
Excellent. Very helpful list for people to work through. And yeah, it's sounding like there might be a challenge for employers to think differently about how to achieve some of these roles. And I guess that's what the impact of the legislation may have across industries.
And I might just say, Cass, as well, and we'll go through kind of steps businesses can take. But as you say, it's about how you're thinking about your workforce, and you don't have to be just responsive in this area. So businesses that might be 5 day a week might actually decide to be proactive and think about different buckets of employees that could work from home and actually offer it to them before just waiting for notices or requests to come through. So yeah, as you say, you can kind of choose your own adventure a little bit before these changes come into place.
That's really good advice. Really good advice. So from a practical side, this isn't too different than the processes that businesses have around flexible work arrangement requests. So Katie, will you be going through a similar process as you have been going for those kinds of processes in the past? And do you have any advice for people in your HR leadership role? We've got lots of HR listeners on the call about what you think are the best ways to communicate those kind of decisions.
Yeah, I mean, like I said, nothing is really changing, but perhaps just jumping on to something that Andrew just said, making a choice to be a little bit more proactive. So if now the legislation is sort of where our baseline sits, I guess it's an opportunity for us to go, okay, how can we make this slightly better? Like, we don't ever want to be sitting just at we have to do this, or people are expecting this of us now. Like, we're making, we were making a conscious choice when we decided to bring in that flexibility to all of our, at least head office team members, to reduce that commute, give work-life balance. Like, we wanted to be an attractive employer. So now that we're sort of sitting at a baseline with the Victorian legislation, it's sort of a chance for us to go, okay, well, what's next, or where can we improve? And that doesn't mean adding more days, but I guess it means like all those little conditions and things like probation period. Does it matter? Like, why would we do this? Or what does home mean? Can it be somewhere else in the world? Can it be, so things like that. In terms of communicating it, especially when it's going to be, very much in the headlines over the next couple of months, just ensuring our policy is really, really clear from the get-go. So if we can define that eligibility criteria really explicitly from the start, as well as the procedure in making those requests, we can hopefully quell quite a few of those either perceptions of unfairness or disputes from the get-go. If it's just kind of obvious, you are or aren't eligible, and if you are, you're following the same process as everybody else, that should hopefully help us out a little bit. But otherwise, it's kind of just going to be business as usual for us.
Yeah, absolutely. I love what you said about this being an opportunity for businesses to think about how do we rise above the minimum standard. It's being implemented. Maybe it puts pressure on some organizations. Maybe it creates a challenge and some tension for some organizations. But there is an opportunity here to be proactive with the storytelling and the engagement with your workforce. And how do we rise above? How do we create an even better opportunity and be ahead of the curve than just the minimum standard? I really love that thought process. What a great challenge for everybody listening. And so there's a whole other thing that's been talked about on this topic, which is around equipment and dispute resolution. And I've already been part of conversations where people are wondering what the impact of the equipment side and the reasonable cost of things is for employers who maybe haven't got this in place already. So Andy, talking about the cost of working from home equipment and also the increased disputes if an employer knocks back an employee request, maybe you could talk us through where those topics landed. There's been a lot of talk about those online in different articles. So where have both of those topics landed for employers?
And so, great question. And just at the moment, obviously, we're dealing with a bill that hasn't yet receive royal assent. And so we are getting close to the 1st of September, but there is a chance that there could be like little tweaks to this or different regulations to come out. But at the moment, the legislation simply says reasonable costs. And then it again points to equipment and software to access our IT systems. So they've limited it to those two. And then we'll just have to see how it kind of plays out. So there are some groups arguing that it's going to be more than that the cost will be wider, that we'll be paying for an employee's entire internet system and, as I said, dual monitors and things like that. I don't think that's where we'll land. I don't think that's supported by the legislation. So I think the cost is actually going to be quite minimal. I think if I was to think worst case scenario and we're a business that's 5 days a week in the office and we all use desktop computers, so no laptops, then the cost would reasonably be potentially a laptop. And then the cost of spending time to train them how to use the laptop and then access our systems. So there could be some back-end costs with your IT provider or your IT team, some additional licenses potentially for remote, and then the laptop itself. But I think that can all be kind of borne out by the process that you put in place in advance, and why we'll talk through in terms of having a policy, for example, might help that, because you can set some really clear expectations in terms of not incurring any costs without express written prior agreement. So what we don't want to happen is you say, sure, work from home, and they buy a $10,000 laptop for home, and then they send you the invoice, for example. So we're trying to reduce disputes by just being upfront and transparent in terms of the process and costs. But yeah, I would push back a fair bit in terms of this idea that every business is now going to be spending $5,000 per employee. I've seen some numbers out there that businesses will on average incur about 40 to 50K for these reasonable costs. But I always hate those stats because it doesn't make sense if you have 4,000 employees, in the same way that number doesn't make sense if you have 10. So it will be tailored to you and your organization and business. And it is worth thinking through in terms of these proactive steps over the next month, in terms of what these costs will be, what you may want to give in addition to that if you do, and then setting that really clearly in a policy in terms of expectations, because we just don't want to leave. Anytime you leave a situation as vague, an employee thinks that they're going to get this and you think they're going to get this, and it's not clearly set out somewhere, for an employment lawyer who defends a lot of disputes, that's kind of the best spot for dispute, is when you've kind of got mismatched expectations. And from a dispute side, so yeah, as flagged, they can go to the VEOHRC with a dispute, but at the moment, it's not the best tribunal in terms of response times. It's resourcing issues, as a lot of tribunals do. So unless the government puts a lot more money into that tribunal to be able to deal with a huge number of disputes, what's likely going to happen is that it's going to be a very drawn-out process in terms of what that dispute is. And so if an employee thinks that they deserve to be able to work from home and they get rejected, my guess is they're not going to just work nicely for the next 6 months while a tribunal gets back to them. I think what's probably more likely is they're going to take personal carers leave on the idea that, hey, you're behaving so unreasonably, I don't want to work here, or even lodging a workers' compensation claim on the basis that they've now suffered this mental health injury because they're working for such a bad employer. So those are kind of more likely to me. Or third, you might lose good people that say, hey, that sucks, I can't work from home. I'm actually just going to work for somewhere that does allow me to work from home, which is, I would argue, already a risk at the moment. So that those are kind of, the tribunal is kind of the fourth, but it seems lower likelihood to me. In the same way at the moment, kind of disputes around flexible work arrangement requests aren't as nice for employees to use. We kind of see them kind of filter through, but they're not nearly as common, because I think employees would rather kind of the immediate ability to leave the workplace or get money. It's not as helpful for them to go through this drawn out kind of dispute process often, but technically that is the risk, I guess. So if I'm trying to convince upper management or managers below me that we should take this seriously and actually follow a process, it's more in terms of employees going off sick, lodging a workers' comp claim, or just leaving. Basically, it's not so much in terms of like a dispute as part of it. Although we will see kind of big employers kind of get stung as part of that process.
Really good thoughts there, and really good advice. It's always the fundamentals, isn't it? To start with really clear expectations, make sure it's documented, and we will touch on that shortly. We do want to avoid things spiraling into those formal claims though, don't we? So I'm wondering, practically, Katie, what would you say are the early warning signs that a disagreement is heading toward that formal claim world? And when would you say a manager should just pick up the phone to HR or pick up the phone to legal, get some advice, work it through so that we can avoid getting to that VCAT or other formal locations?
Yeah. Very relevant at the moment. I think a really well constructed, long email, sort of about nothing at all, citing some very specific legislation and being a bit demanding, I think is the first tell. So anything AI generated in length. We see sort of early dispute stuff come through like that, most common now. When we would pick up the phone, I think it's like you got to think about, for us to reach the point of even sort of knocking back a request in the first place, we have to trust that it was grounded in good reason to begin with, and that we were within our rights to make the refusal because of inherent requirements or, operational requirements. So I think we first have to sort of go back to that base of like, well, we're a reasonable employer. We're actually trying to do better than this best. And if we were to refuse, it's because that refusal was allowed. But we just want to make sure that our response is correct. It's reasonable, that we are appearing to at least be considering and exploring other options. I probably would just call Andrew regardless, but yeah, I think a level of trust in that we're probably doing the right thing, but it's never going to hurt to get some advice.
I couldn't agree more. And I'm sure every in-house HR leader has their go-to person that they just get on the phone and say, I just wanted to check something just in case. Always great to have an Andy in your corner for sure. Okay, well, let's turn to the really practical stuff of updating contracts, policies, position descriptions, some of these preventative things that are going to stop us from getting into those situations. We've already said document so far on our conversation. So, Andy, what should clients actually be changing in their paperwork before the 1st of September to set them up to succeed in all of this?
Yeah, it's a great question. And it's easy to kind of go through kind of all the different things. And it won't necessarily be changing kind of what the role requirements are or anything about how you operate. Oftentimes it's just actually putting on paper what you already might be doing. So the first one, position descriptions. I'm always an employer advocate. And so I hate position descriptions, or I have in the past, because I was like, why would a business want to restrict what it can ask an employee to do? Like, obviously, that's just my bias coming through. But with these kind of changes, it actually flips it in my head in terms of them being really valuable tools to use, because they give you the ability to really specifically list out the general requirements of the role. And that will really help you down the path if you do end up wanting to reject a request to work from home or a notice, because you can actually go through and mark out all the things they actually can't do while working from home. But if you don't have that document and it's all based on vibes or what you kind of just think they might need to do, then it's harder for you. You end up in a dispute over what the role is rather than just going to what's inherent requirements or not. So PDs are a really good one. Oftentimes, and I would check your contract. Sometimes your contract allows you to change a PD without the employee's approval. Other times you need their agreement. But it can be a good time in the next month to think about that, refreshing them, getting buy-in from employees, because oftentimes employees do want to know what's part of their role. So PD is a really good one to go through. Having kind of a work from home flexible policy is going to be really important. And Law Squared is actually pushing out a free one that we'll send out after this webcast in the next couple of weeks, once the bill is finally kind of approved, that people can download, but it'll give you kind of a good starting spot for kind of what a policy might be. Employment contracts, useful in the way of one of the exceptions for making a work from home request under these new changes are whether they're on probation or not in their contract. It doesn't specifically set out exactly what that means, but how we're interpreting that is simply that the contract sets out that for a first, say, 6-month period, they're on probation. It's just extra reason to make sure that that's in the contract, because, again, that just gives you more flexibility. You could always accept a request to work from home from someone on day one, but that kind of gives you that kind of better protection. And then to kind of think through, I guess, in terms of how we're categorizing employees is going to be useful as well. So for one client, I recommended that they create a bit of a spreadsheet and they kind of group employees into categories of could do 2 days a week from home, can't do 2 days a week from home, because they're already, and then they can see kind of how they want to push out that policy in advance, potentially, rather than just wait for requests. But that's really useful. And then trying to think through in terms of what the costs might be in terms of those approaches. So it's all very well and good for me to say, hey, you should let employees work 3 days and put out a policy. But obviously, the finance side need to know kind of what the costs might be of that. How much would the setup kind of process take? What are the costs for laptops if we don't have them, for example? And so they can make kind of a decision on that. But those are kind of the main ones that I'm kind of thinking of. So PDs, a policy and contracts, and then kind of your own planning, as Katie was kind of mentioning, in terms of kind of how are we categorizing employees, what do we want our position to be, and what are the costs of that. But those are kind of my first few kind of things to think about.
Excellent. So practical, just really valuable things that everyone on the call can take away and take some next steps immediately, which is really helpful. We've covered so much ground already in this conversation. We've talked about the new legislation, what it is, what it's not, identifying roles and working arrangements that are eligible and perhaps not eligible, working through refusal criteria, having conversations, hopefully preventing escalation to any formal forums of disputes. Maybe let's turn our mind forward to the future. Maybe I'd love to hear from both of your thoughts on this. You've both been in people and culture or employment law space for quite a long time. Do you think this is just the start of an Australia-wide change to working from home, or is Victoria going to be left on its own on this topic? What do you think?
Do you want to go first, Katie?
I'll go first. It's hard to tell. I wonder whether, and this is based on absolutely nothing, but I wonder whether at one point or another, flexible work arrangements were radical, and I think whether legislated or not, the sort of current and emerging worker is really expecting hybrid flexibility. And you touched on it before, Cass, where people, or maybe it was you, Andrew, where, people are just saying, well, I just won't go there then. I just won't work there then. It is becoming an expectation, and in my opinion, quite a reasonable one for those roles that can be done at home and what that gives back to the employee, or like that value add. I couldn't speak for the state governments, but I think the message that it sends for not considering it just says so much more than perhaps what those traditional employers think it does, and it might cost them in the end.
Yeah, I think that's a fair point. And I always see these changes as like a lag rather than a leading kind of change. So I think it's something like this. In my head, it's not that hard for people to get around, because it's trying to capture that last 10, 20% of employees that don't allow any work from home, where 80% have probably already moved in another direction and allowed it. Like, just speaking from a place of bias, like I'm currently doing this webcast in Queensland and I normally live in Victoria. So maybe I'm a bit biased in terms of the practicalities of flexible work, but for people, they've grown up like me, this is now becoming a bit more of an expectation, or at least something that would require a bit of reason as to why it's being pushed back on, if we're able to then focus on output rather than just input. So I don't know, I guess, just speaking off the cuff as well, Katie, in terms of other states, I think it probably depends on how the polling goes and if Labor ends up winning the next election potentially. People always love to look at policies that come out and then the government either wins or loses as whether other political parties may take the chance. If it comes out, it's very well loved and Labor ends up winning the next state election, I think we'll be in a much better spot for other states to kind of potentially follow. States are very competitive from what I've seen. So people, in the same way we don't like to be left alone, a lot of states also don't want people to say it's better to work in Victoria than it is in New South Wales, for example, or Queensland. So I think it will be based on just what the people are kind of pushing for and whether they see value, I guess. But yeah, I'm keen, Cass, I know that you've had a lot of experience working overseas and different global entities. Do you think this is also being pushed in other kind of countries besides from Australia, or does this feel very much like a local, generous Australian entitlement?
I think it's remarkable that it's a world first, given that working from home really emerged and took over during COVID. So we're nearly, we're many years on from that now. So it's remarkable that this is a world first. It's the same as Australia in other countries that I've been interacting with as well, in that there are some people who are very progressive and very flexible and leaning into what you were just saying, Andrew, about being in various locations and being absolutely comfortable with that, and others who are still demanding the 5 days in the workplace and not being able to consider or see a way of working and building a productive, engaged workforce without actually being in person. So I think it is going to be challenging for different people for different reasons. But it's really interesting that it's a world first coming from Australia. I think what's important for businesses is to be thinking about, as you were saying, Katie, the impact beyond this. So how does this impact your potential for attracting talent? Like when we're thinking about this as business leaders and we're deciding how we're going to approach this legislated new minimum standard in Victoria, what message are we sending to potential employees and current employees about the experience they're going to have in our businesses? So, what are we saying to talent? What are we saying about our progressiveness in general across many other topics, not just working from home and flexibility? So there's a lot to be considered, I would say. And I would hope that businesses are using this as an opportunity to be challenged. And as you were saying again earlier, to see it as that opportunity for thinking differently and not holding on to how things have always been done, but maybe even experimenting with different ways of operating and seeing if there is opportunity in that. So probably I'm also leaning very hard in the same direction as you, Andy, but that's not true of every business and every leader. So, be interested to see how this plays out for everyone. Speaking of COVID, which I don't ever want to say again, sorry that I've made the link in that way to the next question, but because working from home did skyrocket during that time, we've had this conversation before that employee claims have also skyrocketed since that time. And Andy, I'm wondering if you think there's any linkage between those two things, the working from home and the increase in flexibility and the increase in claims. And maybe does that contribute to some people's hesitations around this kind of new legislation and this push into a different direction?
It's such a good question. I don't think so, in all honesty. I was hoping, to be honest, that once we all went work from home during COVID, that would be less weird as employees and we would do less weird things. But from my experience and the work coming to me and from clients is that the number of allegations of bullying, sexual harassment, victimization stayed the same, if not went up slightly, which made no sense. I guess it's just in my head, I should keep reminding myself that if you're a creepy or gross employee, you're probably just going to be creepy or gross virtually if you can't be in person. So I heard a story from a client. They had an employee that was being bullied by another employee and they were still working from home. And during all Teams calls, she had a Post-it note that she would put on the face of where the alleged perpetrator of the bullying, just so she didn't have to see him in these Teams calls. So it just kind of is evidence that the impact of these kind of inappropriate behaviours are still there just as much as if they were in person a lot of the time. So it hasn't actually had that impact in terms of reducing claims. In the same way, I don't think it's necessarily an indicator of why our claims have gone up. I think some more like anecdotal evidence looks more in terms of employees being less scared to lodge a claim. So we're just getting more publicised decisions in terms of decisions going the way of employees, and they know that an application only costs $70, $80 now. AI is actually what the Fair Work Commission has come out with, is actually lowering the barriers to entry for applications to come through. And the Fair Work Commission is funny in the way that they don't love AI being used by self-represented litigants in terms of its accuracy all the time, but it still thinks it indicates that it still thinks it's better than when they were trying it on their own, which I always think is quite funny, but it has led to an increase in claims. So I would point to more those two things rather than work from home as being the indicator. And that largely our ability to be inappropriate in the workplace has kind of stayed the same from what I've seen. We're just using different avenues to do that, basically. and our awareness. I always look at, there's this stat where there was this report that they did in terms of sexual harassment committed via virtual means, and they found 1 in 6 people admitted to engaging in sexual violence or harassment via technology. So they actually admitted to being a perpetrator by them not asking the question, are you a perpetrator, but just asking, have you done these things? And 1 in 6 said yes to things that would constitute sexual harassment in the workplace. And it just shows kind of how bad we are in terms of the education piece and our self-awareness. Oftentimes people are running those training classes being like, yeah, I know what's inappropriate or not. But the stats don't actually back up that it's sunk in for a lot of Australians. So, no, I would push back that this is a direct connection to COVID work from home. I would probably point at some other things first.
Really interesting insights. And I guess the flip side of that is true as well, isn't it? It's like a great organization relies on great leadership, great culture, conversations about the right things, having your expectations documented really clearly. So whether you're online working from home or you're in the office, all of those things are still the things that make an employment situation and an organization great. So really
Absolutely.
interesting.
And I would just say, like, I feel like I should come to the defense of the 10, 20% of businesses that don't want people to work from home. Like, oftentimes there's valid reasons that they don't want people to work from home. There's a fear in terms of whether those employees could potentially use technology in the right way. They might actually have clients that prefer coming into office and seeing people. Like, I just would push back also that businesses are like run by bad people. There was a report the other day overseas that tried to make the link between the only predictive measure of a CEO wanting people to work from home was that they're narcissists. And I just, I think it's interesting to read those things, but I don't think it's backed up by a lot of clients that we might have that don't want employees to work from home. I think they might have valid reasons that employees may not agree with, and maybe these laws will push them further away from. But they're oftentimes just wanting to do the best by their businesses, I guess. So I know I like to criticize a lot of businesses for being quite rigid, but I did just want to briefly come to the defense of employers that have maybe taken a more traditionalist viewpoint so far, just in case my comment section kind of goes very anti what I'm saying.
It's a really important point to make. And I guess the assurance is that the legislation has been written with those carve-outs in place for those legitimate situations where you need people in your location of work. It still is possible. And you can go through that process and show that on a merit case by case basis. So yes, absolutely, for those businesses where there are valid reasons, it's still possible. So that's a positive thing and really important to call out as well. Well, we're just about out of time. Before we close, I'd love to hear from both of you. Again, what we love with these sessions is to make sure that we're sharing the information in its full sense, but also to make sure it's super practical and people know what they can do as a next step. And so I'd love for some advice from both of you about what our listeners should do in the next 30 days to get ready for 1 September. What would your advice be? What's the next step that they could take after this webinar?
My initial kind of takeaway is to not panic, I guess, at this stage. You have another month. So another month, if the bill does come through on the 1st September, to kind of start asking these questions and to look at the policy Law Squared will push out, to think about what policy you want to kind of have discussions with management in terms of what position, if any, needs to change from the 1st September. And then always to know that you have, worst case, 21 days. So if someone lodged a notice on 1st of September, you still have 21 days to consider, to negotiate, potentially to go back to the employee. So I think some of the articles make it sound like the whole world's falling down if you don't do something in the next 2 days. Worst case scenario, you basically have 2 months to kind of have a position. And even then, you might not get requests on the first day. So that's my first takeaway, is just not to stress too much as part of it. And then to just, as I said, to kind of ask the right questions over the next kind of 2 months in terms of what kind of workplace do we want to be, what is allowed to happen or able to happen for us, and then what flows through from that are all the boring document stuff. So PDs, contracts, the policy, that kind of reflects what you've decided. But you've still got weeks and a few weeks to kind of make a call on what position you want, and then everything else kind of flows through. And then you can always ask questions of different people if you have them as part of the process. But yeah, maybe that's my classic don't stress and ask the right questions over the next few weeks. Maybe that's not that helpful, but that's how I like to think about it when clients ask me. And now, hopefully, that's enough time, Katie, to pass over to you.
I think I would probably echo a lot of what you said, Andrew. So I think maybe first of all, getting your categories in place if you haven't already of who is just flat out no need to worry, or getting really clear on in the situation that they did make a request on what that conversation might look like. And then possibly scoping out, or asking yourself the question of, do we want to start just proactively offering to anybody else in that sort of middle category, the ambiguous senior management one in our example. If we're not going to go that way, but we are going to go with, well, they might request and we might want to refuse, I guess, testing our reasons why or why not, like determining what our comfort levels are, basically, and then sort of, I guess, testing the answer that we come up with, and are we satisfied that that's a real answer, or is it, are we proud and comfortable sharing that answer, or do we need to sort of check our thinking again?
Excellent advice from both of you. Thank you so much. Well, today we've unpacked quite a lot. We've unpacked what Victoria's new work from home right actually means from 1 September 2026. Andy has taken us through the legal side, but as Katie and our whole conversation has shown, the legal framework is really only half of the story. How we categorize roles fairly, communicate decisions, and manage the human side of a no decision is what will determine whether these are smooth processes or a potential dispute. I think what I've heard from the conversation today is that the businesses who will navigate this really well are the ones that are getting their documentation and processes sorted now. And it sounds like the message might be that this may not only be a Victorian topic, it may be a signal for where the future of work in Australia is heading. And I'm really curious to see how that unfolds over the months and years to come, as I'm sure are many of you. So I want to say a big thank you to Katie and Andy for your time today and for sharing your wisdom, expertise, and experiences with us. It's been incredibly helpful, and really want to say thank you to everyone for joining. We hope you've taken away some practical next steps. We will be sharing an on-demand version of this webcast over the next couple of days if you'd like to share it with your colleagues. We'll also be sharing an FAQ with answers to the questions that you've added into the chat today. So thank you for contributing in that way as well. If you would like some further guidance on the changes we've discussed, we will be sharing a free work from home policy with you to help set the groundwork when you're creating a policy tailored to your own business. And if you do need help with navigating updates to your contracts, policies, or position descriptions, or anything else that we've talked about, you can reach out to Andy and the employment team. Their details are in the chat right now, and they would be more than happy to assist. So thank you all once again for joining. Really looking forward to seeing you at the next one. And for now, just have a great day.